Welcome, everybody. Just before we dive in, we are an organization that offers all of our services free to parents with children with disabilities in Minnesota. We do that both by grants and donations. And next Thursday, if you're coming to part 2 of this series, that's the same day as part 2, we are having Raise a Glass, which is a chance to come together and maybe meet an advocate that you've worked with, hear about our STC program, and mostly just commingle with other parents who are learning about or know about our services. So I'm not always savvy, but I think if you scan that QR code, it'll bring you to how you do that. Yeah, otherwise you can go on our website. But why don't we go ahead and get started? So welcome to a series. This is the first video in a series called Understanding Special Education series. Part 1 is about the process of special education and the rights of parents and guardians within that process. Please know that we are not a legal services agency and we do not provide legal advice or representation. The content of this presentation and related materials are for informational and educational purposes only. It's not legal advice and should not be used as a substitute for legal advice. Also important to know that our workshop is geared towards Minnesota parents. Professionals, I think it's good for you to understand what we're teaching parents. If you're in another state, IDEA, the main law stays the same, but things like timelines and paperwork may differ in your own state. So we can help you find that state PTI for your state if necessary. Judy, you want to go first?
Sure. Good afternoon. I'm Judy Sweat. I came to PACER in 1996 after years of advocating on behalf of my daughter, Joanna. Understanding her needs and knowing my rights made me a better advocate for her.
And I'm Robbie Weil. I've been at PACER for only 7 years. Compared to Judy, that's a flash in the pan. But I was a teacher for 35 years, and 2 of my now grown children received special education services. I never knew to contact PACER. I thought I knew the system because I taught in the system, but I spent the first couple of months at PACER trying not to second guess the decisions that I had made. At whatever point you are with your child, it's never too late to start learning and advocating. So as I mentioned, we are the PTI for the state of Minnesota, and that is our role. That is what we do. We are happy to help you find your own state. You could also go on to Parent Hub to find information on your own state. We are a trusted source of information, training, and support for families of children with disabilities. We help families and youth navigate special education and other complex systems, discover assistive technology solutions. We have an amazing technology center, and access bullying prevention resources. We are the only organization in Minnesota that supports families of children and young adults with any disability from birth to age 26. Couldn't remember what that had changed to. So that is our role. That is what we do, and that's why we are here today. And again, all of the things we offer are free to Minnesota families.
Our presentation today is the first of a 3-part series.
Sorry.
It's okay. Today's presentation, Process and Rights, is intended to give an overall understanding of the purpose of special education, its place within general education, the principles of the Individuals with Disabilities Act, the process, and the role of parents and guardians. Next week from 12 to 1 on September 18th, we will define special education evaluations, explain their process and receiving the results, and provide an understanding of options moving forward. It will also discuss eligibility for special education services. The third and last presentation at the same time on September 25th will focus on the individualized education program itself. We will review the parts of the IEP and dive into understanding its goals, services, and accommodations. It will also include a brief overview of the prior written notice, or PWN. You should, um, our, our learning targets for today is: what is special education? What are the steps in the special education process? And what is the role of parents and guardians? You should find a question panel on your screen. You can use that to submit any general questions you have for us along the way. We have a lot of people in attendance, so we do our best to stop a couple of times to answer any questions as they fit into the presentation. However, we're going to have a time for questions and answers at the end of the presentation, so it's really better if you hold your questions until then. Please keep your questions general about the process. If you have a very specific, complex, or personal situation to ask about, your best option would be to contact PACER and ask to speak with an advocate. That link is on our website. We will also share it at the end of the presentation.
Ooh, my advance button isn't working. Hang on, everybody. Sorry, we're having a little glitch. There we go.
Good, because I don't have a button.
So what exactly is special education? The goal of the general public school education is to provide students with what they need according to the standards set by the state. When children are struggling, the school has a responsibility to address these concerns, whether that be through small groups, intervention programs, Title I, or other options. But sometimes it's clear that that children need more, and there are two laws that protect and serve those students. The first one is Section 504. This is part of the Rehabilitation Act of 1973 and protects the rights of people with disabilities participating in programs and activities receiving federal funds. In order to qualify for protection under this law, a person must have or be regarded to have a disability that results in impairment of a major life function. And because learning is considered a major life function, the public school may not discriminate based on disability. All children are to be given access to the general education curriculum. Children with disabilities may need accommodations to ensure that access. We are not going to be focusing on the 504 today. There are no specific federal or state laws regarding how this happens other than you can't discriminate. Each district will have a 504 coordinator to contact and discuss the need and the process for a 504 in your district, if that's something that you are pursuing. And again, the 504 does not give services primarily. It is about accommodations. It's about leveling the playing field so that your child with a disability can still access their education. The other law that we will be focusing on today is the Individuals with Disabilities Education Act, or we call it IDEA or IDEA, and that is the focus. There are many rules and regulations governing this process, including timelines, yearly reviews, due process paperwork, and participation of all members. Parents and guardians are an important part of this process and participate best when they understand both their rights and their responsibilities.
The 6 principles of IDEA that we're going to discuss today start with FAPE. This principle mandates that all eligible children with disabilities, regardless of the severity of their disability, are entitled to a free and appropriate public education tailored to their individual needs. This education must be provided at public expense and must meet state educational standards. The next principle is participation. IDEA emphasizes the importance of involving parents and students in the special education process. Parents have the right to participate in IEP meetings, provide input on their child's educational goals and services, and collaborate with educators to ensure their child's needs are being met effectively. Similarly, as students mature, they are encouraged to participate in decisions about their own education to the extent appropriate for their age and their abilities. The next principle is evaluation. IDEA requires that schools conduct comprehensive evaluations of children suspected of having a disability. These evaluations must be conducted by qualified professionals to determine if the child meets the criteria for special education and related services. This process will be covered more in depth in our presentation next week. The next principle is the IEP. Each eligible child must have an individualized education program, or IEP, which is much easier to say, that outlines their specific educational goals and the services and supports necessary to achieve these goals. The IEP is developed by a team that includes the child's parents or guardians, educators, and other specialists. The next principle is least restrictive environment. Children with disabilities should be educated to the maximum extent appropriate with their non-disabled peers in general education classrooms. This is referred to as the least restrictive environment. Placement decisions must be based on the child's IEP and should minimize segregation from their peers without disabilities. The IEP and the concept of LRE will be addressed in depth during part 3 of the series on September 19th. I'm sorry, I think that's September.
Oh, 25th. Yep.
Yeah,
Good catch.
okay. And then finally, procedural rights and safeguards. IDEA guarantees certain procedural safeguards to protect the rights of children with disabilities and their parents. These safeguards should include parental involvement in the decision-making process, the right to examine educational records, and the right to challenge decisions regarding their child's education through due process. The first step in helping a child is understanding the child's needs. This is done by looking at various data that is collected for all students, like grades or state and district assessments. There is a very specific process for evaluating the need for special education by conducting a special education evaluation. We'll go deeper into this in the next segment. If a child is found eligible for special education services, the next step is to create an individualized education program, or IEP. The team must come to agreement in prioritizing needs, creating goals, deciding services and supports to meet those needs. IDEA states that a child with a disability may not be removed from the regular education environment if the child's education can be satisfactorily achieved in regular classes with the use of supplementary aids and services. Last step is the roof placement. Not a place 100% a percentage of time. Okay, placement is not a place. It's the amount of time from typically developing peers to receive agreed upon services. The goal is to find the least restrictive environment, balancing the individual services a child may need away from their typically developing peers with their right to learn alongside their peers. So placement is the last decision that is made after determining the services and supports, the needs and the goals on the IEP.
So, given the power that family involvement has to influence how our children achieve in school and in life, it's not surprising that the nation's special education law, IDEA, strongly supports parents' rights to be involved in the special education their child receives. As IDEA states, almost 30 years of research and experience has demonstrated that the education of children with disabilities can be made more effective by strengthening the role and responsibility of parents and ensuring that families have meaningful opportunities to participate in the education of their children at school and at home. Once a year, parents and guardians are given a packet of their procedural rights and safeguards. Often parents, and I include myself in this, are so overwhelmed by the evaluation and the IEP process and how are you going to help your child that we never even read this packet. And at the very end of that packet, it usually says something along the lines of, this is a lot to learn. You might want to reach out to MDE or PACER or ARC, and gives the information. And like I said, I never read that packet. So let's focus on some of the important rights and responsibilities. Under the part of IDA called child fine, under federal law, public schools and districts have a responsibility to identify students with disabilities attending public and private schools located in their district who may need special education services. Sometimes the school may suggest doing an evaluation to collect data, but parents and guardians also have the right to request an evaluation. We'll talk more about that next week. You also have the right to review and make copies of your child's records, including report cards, transcripts, disciplinary records, contact and family information, cumulative files, and special education records. You can ask that the records be explained to you by a qualified staff person. You can also ask for misleading or inaccurate information to be removed or changed. You also have the right to have your opinions and concerns be considered. You are the expert on your child. The school members of the team hold the expertise in terms of pedagogy, curriculum, and how your child is impacted by their disability during their school day. Sometimes there is a discrepancy between home and school. That doesn't mean that somebody did something wrong. It needs to be explored, for example, looking at academics or deficit or anxiety. You do not have to go it alone. Take notes. You can bring anybody to take notes, bring relevant information, or just to kick you under the table if you're getting kind of hot. But you have the right to have anybody included in the meeting that you request. I think one of the most important things is that you never have to sign anything on the spot. The only thing you need to sign in a meeting is the attendance sheet. And by the way, you also have the right to ask the meeting to be postponed if somebody that you think has very relevant information is not at the meeting. But that would be the only thing that you have to sign. You always have 14 days to decide once you are given a proposal following a meeting. You decide if you're in agreement or disagreement with anything, and you have the right to ask for more information or to ask for anything unclear to be explained. You have the right to object and ask for a meeting to come to an agreement. Agreements and objections are done using a form called a prior written notice, and we will go a little more deeply into this in part 2 of our series next week. The other thing to know is that a lot of this information is on our website, which is updated and very accessible now. If you go to pacer.org and you type in prior written notice, you should be able to find articles to explain, but we will cover that next week. So these rights that are part of IDEA give you the power to be an equal member of the team, but as Spider-Man would say, with great power also comes great responsibility. You have the responsibility to understand your rights. You cannot exercise your rights if you don't understand them. Many parents call us when there is already a problem that could have been avoided had they known how to express their concerns or how to object. In my best world, if I win the lottery, every school does a back to school night for families understanding the rights. But that's not where we're at right now. That's why we're here. You also have the right to learn as much, or the responsibility, I'm sorry, to learn as much as you can about your child's disability and how it impacts their education. I will get calls from parents and they say, well, but I'm not the first child with ASD, but your child is an individual and that may impact them very differently than other children. That's the historical perspective that you can bring to the team. There are parents who call us and their child has a very rare syndrome or a diagnosis that the school has not dealt with before. So the more information you can bring could be vital in the decision-making process and collaborating together. You have the responsibility to make informed decisions about your child's education. And that's why being here today and becoming informed about the process and your rights is so crucial. So again, we're glad you're here. Learning to communicate in an effective manner allows teams to work collaboratively. When you think of it, you're in a business partnership with the school, and the product is the education of your child. Disagreeing is not being disagreeable, but there are ways to do so that preserve the relationships with other team members. Somebody asked earlier, made a comment that, the school feels like they're over-involved. There's a balance there. We do have a workshop on our YouTube page, which you haven't checked out, YouTube Pacer, about effective communication, because there is a little bit of an art to it. And we also have some articles also on our website. But it's reaching that balance and communicating effectively and in a reasonable way to help move things forward. And when your child is on an IEP, it is really important is to keep the focus on your child. Your feelings can be dealt with in different ways, but the focus is to work together to create a really good product, which is that free and appropriate public education. Keeping the focus on the child and the goals for the child can keep things moving forward. Oh, didn't realize we were already there. We are at our Q&A. So
And
go ahead and put your questions in the chat box.
please do. I've answered some of the ones that have already come through, but with 114 participants, I think there could be a whole lot of more questions to be asked. So we'll give you a little time to put them in the Q&A box. One of the questions that we've already answered had to do with the parent not knowing that after 14 days, if you don't send in your parent consent object form to the district or to the school, that IEP automatically goes into effect. If it's the subsequent one, if it's the first IEP, nothing will happen until you give consent or you object. And if you're anxious to get your child services, it's important that you send that form back in as soon as you've thoroughly read the IEP and know whether you agree or disagree with it. You don't have to wait the 14 days. It's just that if it's the subsequent IEP, after that 14th day, on the 15th day, it automatically goes into effect.
I want to pop in and answer one. There's a question where a parent has been told, a guardian has been told that the IEP goals do not cover grade level work. When you think about it, the goals are the scaffolding to help them make progress not only in those goals, but in the general education. So, for example, let's say a child has a disability in math. And I taught fourth grade primarily, so that's a big year for learning multiplication. You wouldn't have as a goal that the child will be able to do double-digit multiplication. The goal is to build the skills that the child needs to optimize their chance to make progress when they are in the general education. So they're connected. And this is, and you have a right, again, with everything here to agree or disagree, including the goals. There can be pull-out time to pre-teach. This parent is saying that they do a lot of work at home so they don't get behind. If a child is struggling or needs things one-on-one or needs repetition, part of their service minutes can include pre-teaching what's going to happen in Gen Ed or reteaching what has been taught in Gen Ed. So that can be addressed in different ways. And again, these kinds of questions, I'm happy to give you that general overview. If you have specific questions about your child's IEP, again, the best way is to contact us and we can look at that document with you.
Another question that just came in, do As a parent, do you have the right to say, no, you cannot evaluate my child? Yes, you do. If for some reason you do not feel your child needs special education services, or you're not interested in those services because you're doing something privately, you do have the right to say no to the evaluation.
I'm going to pop in and answer a really quick one and then a little bit longer one. Somebody again asking about if we are Minnesota specific. Pacer as an organization is Minnesota specific. So any of the things that we share online are available to anybody, but we will only confer one-on-one with Minnesota parents. And again, we are the Parent Training and Information Center, and that's part of IDEA that every state has to have one. So we're happy for you to use our resources. Again, you can go to Parent Hub, or I think it's cipr.org to look up the PTI in your state. That being said, there's another question here about, two parents who may be in disagreement. Um, That is up to the parents. It is best when even if you are not together, it is best for you to present a unified, Judy, what am I, to present together,
Yes.
to have discussed it and share
A
your,
unified front.
yes, and be on the same page. Thank you. That's what I was trying to find the words for. Um, One parent can sign and give permission. And if the other parent disagrees, that puts the school in a really difficult spot. And that's when very often we suggest you, if this is a divorce situation, you might want to go back to your mediator or attorney if there need to be bigger decisions. But only one can sign. If one signs and says, I agree, and the other says, I disagree, you've put the school in a difficult position. So the more you can be on the same page, the better.
Does PACER find, also, how does PACER find advocates to work with parents in the schools? All PACER advocates, that's our role to do that. So if you're looking for a PACER advocate, you simply contact PACER, ask to speak with an advocate, and then we work with you to help you better collaborate with the schools in order to get the services and supports that your child needs in order to be successful.
And I think we all feel very strongly that our job is to empower you. As one of my colleagues says, we're just people sitting in an office trying to give you information. But our job is to empower you to be the advocate. I just wanted to address a question here about the resources. I believe that when you got the link after you registered, you should have received some resources along with that link. One of them is a resource page, and one is a PDF of the slides with note-taking space. If not, those are sent out again 24 hours after we're done. And so if you don't receive that, reach out and we can get it to you, but that should come automatically. Go ahead, Judy. This is your expertise.
Okay. Are there any differences in parent rights when my child transitions from Part C to Part B services? No, your rights are the same in both situations. The only thing that changes when your child transitions to Part B from Part C is services are really focused on the educational needs of the child. They no longer look at what are the needs of the parent to help the child develop and grow. So your part in your child's education minimizes just a little bit. Before, you're used to having the providers come into your home, work with you to develop strategies for you to help your child learn new skills. Once they're in preschool, you don't have that close connection with the staff. However, you should always be given information on how you can help support your child's learning at home.
I want to address, there's a question here about what kinds of evaluations can be done. If you are new to special education, or at any time you're asking for a reevaluation, your job is to share all the areas where you have concern and then ask the school how they assess that. There are, I can think off the top of my head of three different assessments that could be used to look at academic progress or to look at, you know, intelligence and that ability. It's not really about what test they use, and that sometimes comes down to what test the school owns and who they have people trained in to do those assessments. Um, Sometimes this is when parents call and we all help them kind of clarify what are my concerns. And that process and then meeting with the school to talk about that results in a plan of what areas need to be assessed and then the school suggesting what assessments they would use. I think all of us as advocates have parents who call and say, can we look over this eval plan? And sometimes I'll say to a parent, I'm seeing that they've covered everything that you had shared with me were concerns. And sometimes I'll say, here's an area I'm not seeing. Was there a discussion about that? Was that decided against? Or what are your options? The important thing to know is that whether your child is homeschooled or in a private school, you still have the right to be evaluated by the district. Private schools do not provide special education. The process is a little bit different. Often children will be bused to the public school for their services. But the process of planning and going through with an evaluation is the same.
Oops. I was just starting to answer a question. I think that I will go ahead and
Oh,
just
type it.
go ahead and type it, Rob, if you want to take the next question.
Sure. There's a question here, couple different things. I'm going to talk on this. Oh, you're addressing that one. Sorry, Judy. There's a question here about not getting information. Again, there is a balance there. When you are trying to work with the school, there is a limit. Part of this is just finessing how you and the case manager are going to work together. And that case manager is your most important point person. And as a matter of fact, on a new series of videos we're working on, and when we talk to parents, the first thing we typically ask is, have you shared your concern with the case manager? That is your point person. When you are getting pushback, I think part of what we do is talk through how are you contacting them. Some people say, well, I only text them every day. That may be too much. Um, some people say, I've emailed twice in the last 2 weeks and I've not gotten a response. That is hindering your participation. And that can be addressed in a team meeting as well. This is another area where we talk to many parents to kind of suss out, are you asking for more than you're obligated to? Are you asking for what is reasonable and you're not being heard? And then we can discuss your options as to what you might want to do about that.
Let's see. They're flipping. What can we do if the school keeps fighting back on making changes to an IEP, like a para or updating the FBA? It depends on why the school is fighting back. The IEP only has to be updated once every year, unless there are changes to the child. Maybe you've got a new diagnosis, or if the child is not making progress on the IEP. If there are behavioral concerns, again, an FBA only has to be done at a minimum once a year. So what would be updated would be if the behavior intervention plan is not working, then you could ask for changes to the behavior intervention plan based on what was discovered through the FBA. The FBA is a functional behavior assessment, and it's sort of supposed to give information about what happens prior to the child behavior, and then what is the behavior, and then what is the consequence of that behavior? What does the child get out of exhibiting whatever that behavior might be? And so usually that information doesn't change throughout the year, but what might need to be updated would be the behavior intervention plan.
I'm going to jump on this one. This is from a professional within the school system. How do I support parents that want to have an IEP meeting and the school is saying they haven't had enough time yet with the student? I guess the easy answer is have the parents call us because we can talk them. You have the right to a meeting. And again, sometimes we will listen to a parent's concerns and look at all the options. But that's kind of on an individualized basis. And again, IEP meeting is a right. And if they're getting pushback, then they can ask for that denial in writing. But I would suggest that you have all, and I would say this for most professionals. We as a rule do not consult with professionals. Our grants and our funding are to support parents. And I'm going to kind of jump into another question before about who provides individual advocates. Our job is to empower parents. You are the only one who has the history of your child. You are the one who knows your child best. There may be organizations, and I know there are definitely for-pay organizations that will send an advocate with you. Because you are your child's advocate from the first day of kindergarten until when they end, whether that's in 12th grade or they're receiving services, and you can receive services through transition programming up through their 22nd birthday. Our job is to teach you how to do that, how to separate your emotions. Again, I would suggest you watch our YouTube archived webinar on effective communication. There are resources out there, but I don't know what they are. And I guess my concern about that is that all of this is supposed to be free to parents. FAPE, free and appropriate public education. And if parents need to pay someone to be able to advocate for their child, then we're talking about some equity concerns. You want to jump on one, Judy? Otherwise, I got another
I'm
one.
typing the answer to
Oh,
it.
okay, go ahead.
Jump on. I think where we're at,
Mine are jumping all over the place.
yeah, if due to their disability, a student cannot meet specific course requirements.
Okay. There's a
Oh,
question.
the dyslexia one.
Okay, you want to do that one or you want me to?
Sure. There's a new law in Minnesota that talks about specific training for teachers who are teaching reading. And so, yes, there is specialized reading instruction for children with dyslexia. Parents do not have the right to demand a certain methodology, but the schools do have to use a research-based intervention for children with dyslexia.
There's a question here. Judy was speaking earlier about Part C and Part B. And it's actually kind of backwards because the higher letter, the letter further in the alphabet is for younger children. So birth to age 3 is a little bit of a separate system, and that's called Part C. The IEP starts at age 3, and all falls under Part B of the law. And the process is the same, whether the child is 3 or 10 or 18 or 21. So that's the difference. And thank you for asking, because sometimes we forget what people know and don't know.
Or here's an interesting question that I think I'm going to answer live. What are the minimums for FAPE? Do children need to receive minimums of education, i.e. math and reading at the school, or the school provides the materials for the student? FAPE is really about special education, that free, appropriate public education. And so that's talking about FAPE is the services, FAPE is about special education services that allow the child to make progress on IEP goals and objectives and in the general education curriculum. And so the minimums of education would be whatever the third grade or the fourth grade or sixth grade math and reading would be for that particular student. No, I should say for all students at that grade level. And then there's a follow-up. What are the guidelines with EID providers and FAPE? EIDBI providers typically are providing ABA therapy for children with autism and other neurological disabilities. And they do not typically provide any educational component to their services. And they are not required to provide FAPE to students. That this is EIDBI and schools can be kind of a complicated situation. And so if you have a very specific case, you may want to, I would suggest that you call PACER and ask to speak with an advocate.
I clicked on a couple here that I want to reference. The first one was talking about when should you contact PACER, and I would say the minute somebody mentions special education might be something your child may qualify for. Again, it is a very complex law, and there are a lot of details and formal processes, and nobody teaches you that. And again, I will tell you, even as a parent and a teacher myself, I did not understand the process. I thought I did. I thought my job was to sit there and say, okay, where do I sign? Help my child. So I don't think it's ever too early to call PACER. If you don't wait until there's a problem, if you learn the system earlier, you can, nip some of those problems in the bud. And this question was particularly in reference to school avoidance. School avoidance can be addressed by the team. That would be something to contact a PACER advocate to work through. I also want to mention that when we get a call and parents are wanting to discuss concerns about their child's IEP, most of us will request that we see the paperwork. We can look at an IEP and say, that's a great IEP, but I don't know if it's a great IEP for your child. So it's also helpful to keep a copy of that evaluation that is typically done every 3 years. And to share that with us digitally, please. I feel so badly when parents take pictures and I can't enlarge those and look at them. So get a copy of those documents digitally and share them with an advocate. We can look through them with you. But again, it's never too early to contact us. If you're just contacting us to learn the process before that's a problem, great. If there's a problem, we can help you look at all your options. There were also a couple of questions about case managers. So when you have gone through the process of evaluation and your child is found eligible and an IEP is written, you are given a point person. That is the child's case manager. That is your first line of defense. If you have a concern, if you don't understand something, if you're hearing something from your child that is not fitting with what you thought was happening, that case manager is your point person. Somebody said, how many times can we request a meeting? There's nothing in the law about that. It's reasonable, right? Again, if you're contacting a couple times a day, that may be difficult for a case manager. You might want to set those ground rules at the beginning of the year. Is there a better way to contact you? Do you prefer I call or stop in or email? Is there a day of the week that works better for us to be in communication and then to follow that? If a case manager, if you are getting pushback whether it's because you've asked for a meeting or you have a concern and you are not getting a positive interaction with the case manager, there are many, many, many different options. And that's often a good time at that point to reach out. You have the right to escalate to the director of special education. Sometimes that helps. You have the right to ask for different kinds of meetings if you're in disagreement with something. So those are all options.
We have one about, and this comes up a lot in our work here at Pacer. A person has requested my daughter to be in a general education class with a one-to-one aide, but the only option the school is offering is a self-contained classroom, which to me is the opposite of LRE. LRE is the overarching law that says the children must be educated along with their typically developing peers to the maximum extent appropriate. So LRE is inclusion is really a continuum of services, and so you have to look at what are the needs of the child, and where can those child's needs best be met in the context of LRE. And so, people go in and ask, say, my child needs a one-on-one, and almost immediately the school's going to say no. But if you go in and ask and state, well, I think my child's going to need help in this area or this area or this area, or at this time of the day, or for this activity, and talk about additional adult support, and then let the team work together to figure out how can those needs best be met. And yes, if you feel like your daughter is not being given opportunities to be with typically developing peers, along with the necessary supports and services, that would be a time to contact Pacer, and we can talk about your options at that point in time. Oftentimes, school districts will say that a one-to-one aid is more restrictive than being in the general education, than being in the level 3 placement. However, if a well-trained para knows when to back off and when to be there for the student, and so I would disagree with that statement.
There are a couple questions here, kind of generally about, do IEPs run on grade level or skill level, and what is the minimum for FAPE? So remember, the I in all of this process is for individualized. There is no way to say all children with this disability need this many minutes, this many days a week. And in reality, when you're in an IEP team meeting and you've set the goals, you talk about where you want the child to be in 12 months, because that's the time that an IEP is in place for. It's a hypothesis. It's the team, including you, best guess at with these supports, the child will be able to achieve this level of skill. And again, this isn't about general education requirements or goals. It's about specific skill goals that they are working on. That is all there. Again, it's a discussion. When you see that the child has made progress, you may want to ask for an IEP team meeting and say, do we need to change the goal? If a child, and again, you get progress reports from an IEP. It's different than report cards. It's an IEP progress report. And I think we talk about more about that in part 3. That tells you if the child is making adequate progress towards their goal. They're on track to achieve it in 12 months. They are not on track to achieve it in 12 months, or they've already met it. So again, if you think of the goal as where you want them to be, and the service minutes are what you think they need to achieve that, the child has made progress and met their goal, you want to come back and say, well, what's next? Is there still a need there, and what would the next goal be? And if they're not making adequate progress, then you say, what do we need to increase? What needs to change? So there are really no, speech pathologists may have guidelines that they go by, but in terms of the special education, it's individualized based on where the child is and what they need. And just to reiterate, yes, they do not run on grade level. The evaluation identifies what skills the child needs to be successful in the general education, and then the IEP is building those skills. And the goal should clearly state what skill they're working on, where they are now, and where they hope they will be, where the plan is to get them in the course of 12 months.
What processes you feel like you're not getting what you want on your IEP by working with the team? The process would be that you would object to the IEP as proposed by the school district, and then you could request to go through what we call the alternative dispute resolution process. And that starts with asking for a conciliation meeting where you work together, oftentimes with someone a little higher up in authority in the school district, and try to come to an agreement regarding the IEP. You may not always get everything that you want on an IEP, but the IEP does have to meet all of the needs that were educational needs that were identified through the evaluation. And then subsequent IEPs go back to that evaluation, as well as report cards and progress reports and things like that, to make sure that they are meeting all of your child's educational needs.
And scrolling through here. There are a few questions about what is called an IEE, that is an independent educational evaluation. We will go more into that next week when we talk about evaluation and eligibility. Just a brief understanding, since we're not going to dig in deep to that. When you get an evaluation, there should be a meeting to receive that evaluation. You get to ask as many questions as you want to understand it, and you have the right to disagree with it if you don't feel it's an accurate and complete picture of your child. But we will dig more into that next week. This question, go ahead, Judy. Go
I
ahead.
was just going to say, there's a question, what seminar will cover special education IEP reevaluation for a child that needs a different diagnosis? I want to make it clear that schools do not diagnose children. Diagnoses are in the medical field. For an evaluation, it simply is stating a child meets the criteria in one of 13 educational criterias that are set through IDEA and Minnesota state law. And so, you don't need, if there is a new issue that has come up that is affecting your child's education, for instance, you get a new medical diagnosis, you can ask for an IEP team meeting to see if, because of that diagnosis, your child's needs have changed. Oftentimes, the diagnosis, it just confirms what the school has already found, and you don't necessarily need to change the IEP, because the child's needs are still the same. They just now have a name for what might be causing the child's needs. I hope that makes sense. If you have any more specific questions about that, I would suggest that you call and talk to a PACER advocate.
There are a few questions in here about language barriers. And I was an equity lead when I taught, so this is a hot spot for me. You have the right to ask for materials to be put in the language, in your language. If people are using interpreters, and I think this may have been coming, a couple of these may have come from professionals, you want to make sure, if at all possible, that you have interpreters that specialize in special education, or even in education, because Education has its own language, special education has its own language, and now you're trying to transfer that from another language into English and vice versa. So making sure that you have a good interpreter is really important. When people call us, we tend to use language line. We do have someone who speaks Somali. We do have someone who speaks Spanish available. I have found language line to be very helpful. And we do that. I have been working with a parent who speaks Mandinka. So many options there. And again, I think it's clearly an area of need in education in general. But yeah.
There's a question about a child's one-to-one para. Can the parent request that that para be trained in ABA? The answer is no. Parents cannot, as I said earlier, parents cannot dictate methodology, and so they can't, state what training they want that one-to-one para to have. The law does say that the para has to be trained in the child's disability and how that disability impacts their education, and they have to be trained on the IEP, but there's no ability for the parent to request that they also be trained in ABA. We get a lot of questions about that one.
I wanted to address private schools again. We have another question or two about private schools. Private schools are not covered at all under well, for the most part, under IDEAs. Private schools are under no obligation to provide IEP services. However, the district is, and that's where, and now I will say that some private schools do that. There are schools that will create what they call an ISP, I think. But their obligation under the law and the process is not the same. That's why many people at private schools will get an IEP through the district and then coordinates when they go to get their services and how they're supported in school. In very few, but some cases, the school district will come to a private school. It tends to be if they have a lot of students in need, it may be easier and more cost-effective to come to the school. But again, that's something that can be negotiated in an IEP team meeting, and when you're in disagreement, I think I want to focus on that. The focus today is on the process and the rights. And you always have the right to disagree and ask for another meeting to discuss your concerns. And that's something we can support you in as well in understanding your options. But that's a little bit more about the private school piece. I'm just typing an answer here too.
There's a question. Now, I think this is coming from another state, but I'm going to say that in Minnesota, if a child is on medical homebound schooling, they're entitled to 1 hour a day of educational services in addition to their special education services. So the 1 hour a day is for general ed, and then they also have to provide their whatever special education services are written into the IEP. There's another one. Do we have a flow chart of all the meetings that parents must attend and for what purpose? The first meeting that families typically attend is to discuss the results of the evaluation. Then there would be an IEP team meeting at a minimum once a year. Well, the first one would be to write the IEP, and then every year after that, once a year. Now, things can come up. In Minnesota, parents do not attend child study meetings. That's the point when the school staff meet and look at evaluation requests and determine who will be evaluated. Now, if the parents disagree with an IEP, then yes, there might be a conciliation meeting. There could also be mediation after that, or a facilitated IEP team meeting. And so if things are going great, it's usually about, actually one meeting a year, once the evaluation has been done. If there are disagreements, then there may be added meetings. So there's not, we do not have a flow chart of the meetings that a parent must attend, because it really is only the IEP meeting every year.
You want to go ahead and answer another one I'm typing?
Sure. What happens if the team is only following one to two things on the IEP? Request an IEP team meeting, and find out why the other things are not being done. If there's still a refusal or things are still not happening, I would suggest that you contact a PACER advocate and talk about your options at that time. When a child comes into a school district with already having medical diagnoses, the school is still going to want to do their own assessment and evaluation, um, because they do an educational evaluation, which is different than in the medical field. For example, for autism spectrum disorder, the criteria for meeting the educational criteria is different than the medical criteria. And so a child could end up with a medical diagnosis of ASD, but not meet the eligibility, the criteria for the eligibility category of ASD. And so it's comparing apples to oranges. And so the district is always going to want to do their own evaluation and assessment. When the district doesn't, she says the district doesn't believe our daughter has ASD. Sometimes that happens. The district doesn't have the right to challenge a medical diagnosis, but they do have the right to do their own evaluation and determine if your child meets the educational criteria for ASD. Let's see.
Sorry, I'm typing another one. I'm just jumping in.
That's okay. There's a comment here that I'm not sure I understand. The parent themselves could ask to be trained because parent training is included in IDEA.
I think that may go back to the ABA question
Oh,
about can a para be trained? Um,
it's a tricky one.
mhm.
Um, the parent training that's in IDEA is parent training to help the family understand the child's disability, and what it's sort of the supports that they might need. It's not training the parent to be an advocate, or to be an ABA provider in the schools, if that's what that question is about.
And there are questions there about ABA because, first of all, it is a specific methodology that the school may or may not have training that, and they don't have to include that. So, and that gets a little tricky. There's a question here, when a child comes into the district with an ASD or feasibility diagnosis that the school doesn't recognize this, they don't think she has ASD. I want you to work really hard, and this is again about the process here. There is a difference between a diagnosis and an evaluation and finding of eligibility. There are many children who qualify under the ASD category that don't ever have that diagnosis, and there are many children who have that diagnosis and don't qualify. And we'll talk more about this in our presentation next week, focusing on evaluation and eligibility. But the bottom line is you get to decide what areas you have concerns where you want to have them be evaluated, and the child either meets eligibility or they don't. And Judy, we are having so much fun. I just looked at the clock and
Oh,
we
it's
are
1:05.
over.
Yes.
We are over in time. Um, so I think at this point we're gonna stop. Again, if your questions weren't answered or if they're specific, please contact Pacer and ask to speak with an advocate. Um, also want to mention that following this, along with the resending of the additional resources, including the slide with note pages, you will also be receiving an evaluation. Everything that we do is free for parents in Minnesota, and we get that funding through donations, but also through grants. And the way that we keep getting those grants is showing that we are meeting the requirements. It literally is a 2-minute evaluation, and we would really appreciate if you take the time to do that. And I think with
And then once you complete the evaluation survey, you'll get a link to your certificate of
yeah,
attendance.
yeah. So more to come next week. We'll be focusing in on the evaluation process and eligibility, but just know that you have rights. One of the things in your resources is the parent guide to the IEP, and other documents about your right to disagree and how to do that. And we are always here to help. We appreciate you being here and hope you have a good rest of the day. And for most of you, I hope we see you next week.
Bye-bye.
Bye-bye.